Yes. Am I audible? Am I visible to everyone? Good evening. Now we'll go ahead with the today's class. That is MC Ravikumar versus DS Velmurugan and others. Now Justice Vikram, Nath and Justice Sandeep Mehta is before us and giving the reasoning for the same. Now this case revolves around one single question. And that one single question is, can a party or can any person aggrieved by anything have a right to approach the High Court for quashment? The first thing is you need to understand, can a party when aggrieved by the order of the lower courts can go ahead and approach the High Court for quashment petition? Yes, that can be done under 428 and now 482 and now 528 of BNSS, which is talking about the inherent power. The party has a right to file a petition for quashment. A quashing petition can be filed so as to quash the order, summoning order, or charge sheet, or anything whereby he is aggrieved of. But for today, the question is, even if the person has this right to go ahead and file a petition for quashment, and if that quashment petition is dismissed, so for that matter, if first quashment petition has been filed and High Court on the basis of facts and circumstances dismiss that petition, can the party have a right to approach the court for quashment for the second time? The question before the Supreme Court is, does the party have a right to approach the High Court with the second quashment petition? We know appeals are available. If we are not satisfied with the appeal, we can go ahead with from the single bench to the division bench appeal in the same court. Right? But over here we need to understand, can quashment petition be done or not? Both are the same thing. Both are the same thing. There is no such difference. But the petition which has been filed is quashment. Though under this quashment petition, the court set aside the order. Both are equally the same thing. But for a formal way, we cannot say petition for setting aside. But petition for quashment has been made. Fine. So let's just understand the facts. थोड़े से facts घूमे फिरे हुए हैं, but we need to understand. मैंने ये चाहती तो मैं facts हटा के सीधे question की बात करती या बहुत short में लिख दी. But these are the facts which confuses you a lot. And for that matter, you need to understand what is the point for you to stick to and then question the answers. Right? And that is why the facts sometimes become so important for our own analysis. Because in your exam, there will be no question being asked, but rather a one big passage of you for you to understand the facts of that, mark the important terms, mark the important pointers, and then go ahead with the answering. And that is why fact analysis becomes so important. I request everyone to go ahead with reading the judgments more and more. जैसे आपकी reading skills थोड़ी बढ़े. Now moving ahead with the facts of today. Complainant took the loan from the accused respondent and to secure the said loan gave the original deeds of several of his properties to him and an agreement of sale was executed. Over here what happened is the complainant taking the loan and thereby giving as a security the original deeds of the properties and thereby entering into an agreement of sale. It's a kind of mortgage? Yes. Is it a kind of mortgage? If yes, what kind of mortgage it is? May I know? I don't know how to turn off that logo. मैं और बड़ा कर देती हूँ, don't worry. ठीक है? अब is it visible? I know मेरे लिए भी काफी distracting होता है that logo, but I cannot do anything. That is the format we need to follow. Yes, अब I think it's visible. Yes, what kind of mortgage is this? Because we have in our December important judgments, we have understood the different kinds of mortgage. Very good. Now, what is the another name for mortgage by deposit of title deed, which was stated by the Supreme Court? Very good question. Legal mortgage. Very good. Very good, everyone. Good that you remember the same. Okay, over here we are seeing a legal mortgage has been made up. Now what happened? Now let's go back to the facts. Later, very good. Later he paid off the whole amount and requested the return of the original deeds given as security against the loan amount. So complainant took the loan, gave as a security the deeds and entered into an agreement to sell. Later, after paying off whole amount, is requesting back the deeds. Since the accused respondent failed to respond to the aforesaid request, so on this request of returning back, there was no response from the side of respondent. A complaint was registered, but on that complaint, a closure report was filed. What is closure report? So a complaint was registered against the respondent of not giving back the possession of the original deeds. Now, what is the closure report which has been filed by the police officer? Okay, it marks the end of investigation. So, will now the case be registered or there will be no registration of case? Will there be cognizance being taken up? No, it is not charge sheet. Charge sheet is very different from closure report. I will clear that down, but let's just others be answering that. Will now the cognizance be taken by the court or will there be no cognizance being taken by the court? Chalo. Please remember, closure report is filed whenever after the investigation, the police find that there is no valid case to go with. And thereby now the cognizance will not be taken by the court. And charge sheet is the one whereby the court finds some charges against the accused. And thereby now he is requesting and submitting the charge sheet to the court to take the cognizance upon the, no, what is no? Cognizance upon the, your charge sheet. Are we clear? The closure report is closing the case altogether. Moving ahead. To the aforesaid request, a complaint was registered, but a closure report was filed, to which, now a closure report was filed, now to which a revision petition was filed by the complainant. Complainant thought of going ahead with a revision. क्योंकि closure report हो गई, investigation तो वहीं पर end कर दी गई, magistrate ने तो कोई cognizance ही नहीं ली, which got subsequently dismissed. On the revision petition made by the complainant, the revision petition was dismissed by the High Court. On dismissal, now the complainant is filing a special leave petition to Supreme Court, which also got dismissed. Are we clear? So all the procedures of approaching the court are getting dismissed. But while dismissal by the Supreme Court had ordered the complainant to pursue appropriate remedies. Over here, the Supreme Court is stating, the complainant, don't come up to me. Go ahead with the appropriate remedies available to you. To this order, the complainant filed yet another criminal complaint. But on this second criminal complaint filed हुई है by the complainant over here, because the earlier one में closure report हो गया था. But over this complaint, the respondent number 1 and the other co-accused person's quashing request was allowed by the High Court. So once this criminal complaint was made, the respondents went ahead with their quashing petition, which was accepted by the High Court. For the third time, a criminal complaint under the various provisions of IPC was made. Now, अब यहाँ पर जो respondent ने अपने quashing petition फाइल की थी to the High Court has accepted and thereby quashed the second complaint by the complainant. Now the complainant is going ahead with the third complaint. Now over here, he is going ahead and giving the different kinds of IPC related offences. Now to this, summons were issued, मतलब cognizance was taken upon the third complaint. Finally, on the complainant's request, the cognizance was taken. Summons were issued to the respondent, but respondents filed for the quashing petition. On this third complaint, the respondents are going ahead with the quashing petition, which was dismissed by the High Court. And later, after 6 months, another quashing petition was filed. On the dismissal of the first quashing petition, the respondents are approaching again the High Court for the quashment, and thereby the second quashing petition was finally accepted and the whole proceedings were quashed. मतलब पूरा का पूरा जो काम किया, इतनी मेहनत करके थर्ड कंप्लेंट फाइल की, summons, push initiation of criminal proceeding हुई, and it was all quashed by the High Court under the second quashment proceedings. Aggrieved thereby is before Supreme Court through SL. Are we clear with the facts? Agar you're not able to analyze the facts correctly from the very beginning to the end, you will not be able to understand what is the important pointer. Now, can anybody tell me what is the important pointer over here? What is the important point which you need to remember? वो तो मैंने obviously आपको पहले ही बता दिया, तो आप judge कर ही लोगे. But then still, let's see how many of you were actively listening to me and were having concentration. With a lot of confusing facts, another again and again going ahead with the criminal complaint, quashment proceeding. What is the important point of you need to understand and remember? Okay. Multiple complaints and quashing. Fine. Correct. ये तो कुछ चीज बॉदर कर ही रही है. ठीक है, वो तो मैंने आपको बता दिया, इसलिए आप कह रहे हो. बट अगर आप जेन्युइनली सोचो तो देयर आर टू थिंग्स व्हिच आर बॉदरिंग इन Varuni is very correct over there. Multiple complaints being filed related to the same offense, related against the same person, and there are multiple quashment proceedings which have been taken up by the respondent. So both the parties are going ahead with the multiple proceedings regarding the same party, regarding the same offense, regarding the same thing. So initially, one thing is very clear in our head: can this be allowed? Can multiple complaints be allowed when once it has been dismissed, when once it has been allowed but quashed by the High Court, by the Superior Court? So let's just make one thing clear. Regarding complaints, there is no such provision. There is no barring of filing a second complaint. Are we clear? There is no bar as to filing a second complaint regarding the same offense against the same party. If the earlier one was quashed, earlier one was dismissed, there was no trial taken up in the first case, then there is nothing which will stop the party from going ahead with the second complaint. Why? Why am I saying that? Because of the simple matter, for the principle of double jeopardy to come into picture, there is a requirement of a final trial for a final verdict. Either it can be conviction, either it can be acquittal. Until and unless this had taken up, no double jeopardy principle will come into picture. Section 300 of CrPC will not come into picture, right? And thereby the complainant has a right to go ahead with filing multiple complaints. But he needs to stop once there is a final judgment to it. Yes. So nahi. This is a settled principle that res judicata does not apply to criminal proceedings. This is the settled principle. Abhi, I have recently dealt with this also, that the principle of res judicata does not apply to criminal proceedings. Correct. We did, Sai. That is the question, Ishita. Why he accepted? क्योंकि यहाँ पर हाई कोर्ट में ऐसा तो नहीं है दो जजेस हैं. There are the two judges who are taking up the case. There are different judges, different benches होती है. फर्स्ट बेंच ने रिजेक्ट किया, जब दूसरी बार आई तो दूसरे बेंच ने एक्सेप्ट कर लिया. बट बात ये है, क्या ये हो सकता था? क्या सेकेंड क्वॉशमेंट पेटिशन फाइल हो सकती थी कि नहीं? एक्सेप्ट हुआ, नहीं हुआ, अभी we'll talk about. Are we clear? Remember, though the complainant is going ahead with multiple complaints, the respondent are going ahead with the quashment proceeding, Over here, the question is, can complaint be filed? Yes. The principle of double jeopardy will apply only on the final verdict. And we are clear with the fact there are no proceedings which have been taken up. There is no final verdict. Are we clear? Quashment is not a acquittal or a conviction. Okay? Secondly, in case of quashment, now the question is over here. Can the petition for quashment be made? डबल जेपार्टी का प्रिंसिपल तो अभी लग ही नहीं सकता ना. कंप्लेनेंट के अगेंस्ट डबल जेपार्टी कैसे होगी? डबल जेपार्टी तो रिस्पोंडेंट के अगेंस्ट होगी, राइट? नाउ वी नीड टू अंडरस्टैंड. आर वी क्लियर? आई हैव क्लियर योर डाउट रिगार्डिंग कंप्लेंट. जिसके माइंड में होगा, अरे कंप्लेनेंट की भी तो है क्रिमिनल कंप्लेंट बार, क्योंकि क्रिमिनल कंप्लेंट रिलेटेड यहाँ बात ही नहीं की है. थ्रू आउट द जजमेंट, Supreme Court had not analyzed criminal complaints having multiple files. That is not something which the Supreme Court had dealt with. I told you what is the reason for the same, why it is perfect over here. Yes, are we clear now? Can I go ahead with the issue and everything? Please remember, res judicata has an exception. One of the exception being criminal proceedings. Res judicata does not apply in criminal matters. Fine. Yes, important provisions are section 403, which talks about court not to alter judgment, and 528, which talks about saving inherent power of. Moving ahead with the issue. Whether a second quashing petition under section 482 CrPC would be maintainable on the grounds of pleas that were available to be raised even at the first time of filing decision of the first quashing petition. Simply write whether second quashing petition is available or not. Right? Now, Justice Vikram Nath is going ahead with the majority opinion. It is not open to an accused person to raise one plea after the another. Please remember the word used over here. Very restricted first line. It is not open, not to all parties, but the accused person to raise one plea after the another. Matlab, we can interpret that it is open for the complainant or the victim over here to raise one plea after the another, but it is not open for the accused to raise one plea after the another by repeatedly invoking the inherent jurisdiction of the High Court under 482. Though all such pleas were very much available to him even at the first instance. Now, when he filed for the first quashment, for whatever reasons he had raised the second petition for quashment, the same reasons were available at the first, and thereby a kind of constructive res judicata might apply. Though res judicata does not apply to criminal proceedings, but over here we can say the constructive res judicata का principle कहीं ना कहीं आ रहा है, whereby it says if you have the knowledge about any of the facts, you need to raise at the first instant itself. You cannot go ahead with the second petition. We may hasten to add that there is no sweeping rule to the effect that a second quashing petition under 482 is not maintainable. So, Supreme Court over here is stating, we cannot say that there is a general rule as to the effect whereby a second quashing petition cannot be filed. So, please remember to the question, can second quashing petition be filed by the accused? Yes. Yes, but very restricted. We'll deal with it. So, yes, a second quashing petition can be filed and it is maintainable. Okay? And its maintainability will depend on the facts and circumstances of each case. So, right, yes, it is maintainable, but depending upon the facts and circumstances of each case. However, very important, the onus to show that there arose a change in circumstances warranting entertainment of a subsequent quashing petition would be on the person filing the said petition. But this second petition can be maintainable only when the party who is filing the second petition can prove that there is change in few circumstances. Very important. So please remember, there is no bar as to the maintainability of the second quashing petition, but it depends upon the facts and circumstances of each case, and whereby the burden of proving the same is upon the person filing it. The person who is claiming the quashment has to prove. Has to prove what? He has to prove one single thing, that there is a change in circumstance. There is a change as to any fact which was not available to him at the first instance. When he filed the first petition for the quashment, there was something which was not available. And now there is a change in fact, and now thereby this second quashing petition is maintainable. Are we clear? So, as to your question, whether second quashing petition is maintainable or not, can the accused has a right? So, to that, generally he has no right to go ahead with filing the one plea after the another. But having said so, under 482, the accused has a right to file for the second quashing petition. But for that matter, he need to prove before the High Court that there is some change in the circumstance. Very important. Moving ahead. Further, the order passed by the High Court, now Supreme Court is dealing with the case in hand. Further, the order passed by the High Court in the second quashing petition amounted to review, plain and simple, of the earlier order. Supreme Court over here is stating, jahan par the accused is not able to establish to the fact that there is any change in circumstance, and High Court is accepting that second quashing petition. Please listen to me clearly. Wherever the person who is filing for the quashment, that is the accused who is filing for the quashment, is unable to prove or is unable to plead or unable to contend before the High Court that there is some change in the circumstances because of which the second quashing petition is maintainable or should be accepted. And neglecting this point, the High Court is going over there and accepting the quashing petition without seeing into the fact whether there is a change in circumstance or not. Thereby, the High Court is going ahead with the review. Are we clear? जब कोई change in circumstance ही नहीं हुआ है, तो what kind of power High Court is using? High Court is not using the inherent power. Rather, they are using a review power. Is under criminal law review power is available to High Court or not? Tell me. Is High Court have the power to review under criminal law? Very, very important thing. I've already told you many times. Is power to review available to High Court? No. No, it is not available. It is only available to civil courts. Please remember. Appeal power, reference power, and revision powers and review. There are 4 powers: appeal, revision, review, and reference. Civil matters mein everything is available. In criminal matters, review power is not available. Only 3 powers are available: appeal, reference, and revision. Please remember. Very important, very basic thing, but very important. High Court has no power to review. Now, over here, the Supreme Court is stating, High Court overlooking to the fact that whether there is a change in circumstances and thereby accepting the second petition is thereby going ahead with a review power. Since there was admittedly no change in circumstances and no new grounds pleas became available to the accused respondent, the order passed by the High Court is in gross disregard to all the tenets of law, as Section 362 expressly bars review. 362 basically talks about court not to alter judgment. That is, court not to review the power. They cannot alter their own judgment. Review नहीं कर सकते उस चीज का. Fine. Please remember, where is the bar as to review been given? 362 CrPC, and now it is 403. Please remember 403. Fine. Very important for you. of a judgment or final order disposing of a case except to correct some clerical or arithmetical error. If there is some clerical or arithmetical error, that can be done. Other than that, they cannot go ahead with reviewing. Review power is not available to High Court in your criminal cases. Rather, civil courts have all the power. Clear? Going ahead. Further, the counsel for the accused submitted that the second quashing petition came to be filed based on a new ground of plea. Over here, the Supreme Court is stating, in our present case, the counsel for the accused is submitting that the second petition is filed on a new ground. Okay? But from the bare perusal of the record, by looking at the facts of the record, it is evident that the second quashing petition raised no such ground or pleas which were unavailable to the accused respondent at the time of the adjudication of the first quashing petition. Are we clear? So the counsel is claiming that there are new grounds and pleas, but after the perusal of the petition, there was no such ground or plea which were raised or which were not available at the time of first petition. The failure of the accused respondents to raise a pertinent ground or plea which was tangibly available to them at the time of adjudication of the first quashing can in no circumstance grant a right to the said accused person to file a subsequent quashing petition, as it would amount to seeking review on a pre-existing material. Very important. So we understood few things, that is, there is no bar as to filing a second quashment petition by the accused, but that can be only done when there is a change in some circumstance, and that change in circumstance has to be proved by the accused itself. If they are unable to prove it and the High Court went ahead and accept the quashing petition, it will amount to review, which is not allowed. The review power is not available in the hands of the High Court, and thereby the whole procedure becomes irregular. Okay? The whole procedure will become illegal, irregular, because the power which the High Court is not having, they are exercising that power. And which section is important? Section 403 of BNS, which expressly talks about court not to alter their own judgment. But what can be altered is arithmetical and your basic errors, right? Arithmetical and clerical errors can be altered. Other than that, the whole judgment to it cannot be altered. What article 227? Fine. So please remember this thing. Justice Sandeep Mehta had a concurring opinion, that is accepting what with the majority opinion. Now let us understand the precedents over here. Bhisham Lal Verma versus State of UP and another. Supervisory power of High Court. Yes, I understand 227. What are you stating? Can this power of accepting of quashment can be done under 227 or a review power can be made under 227? हम लोग किसकी बात कर रहे हैं? क्रिमिनल लॉ की बात कर रहे हैं ना? क्रिमिनल लॉ की बात कर रहे हैं तो 482 आएगा कि 227 आएगा? मुझे पता है बहुत ज्यादा दिमाग ऐसा होता है कि ये भी तो लॉ है, ये भी तो लॉ है, बट वी कैन नॉट मर्ज एवरी लॉ. We need to differentiate. There is a thin line difference between each and every law over there. Good. Bhisham Lal Verma versus State of UP and another 2023 judgment. It is not open to a person aggrieved to raise one plea after the other by invoking the jurisdiction of the High Court under 482. Though all such pleas were very much available even at the first instance. So the same thing which the Supreme Court had started with. It is not open to the accused person to plead one thing after the another. Remember, aggrieved. यहाँ पर तो aggrieved लिखा हुआ है. हम लोग के में क्या हमारे जजमेंट में क्या accused person. अब तो ये person aggrieved है, वो person accused है. Is there any difference between both the things? Is there any difference between accused person and aggrieved person? Yes, what is the difference then? Good, good to say. Not here. In our scenario, there is no such difference. Whosoever is aggrieved by charge sheet, by summoning order, by going ahead with the cognizance of the magistrate, can go ahead with the quashment. And he is the accused as well as the aggrieved. No, aggrieved is not restricted to plaintiff. No. Accused is a defendant. No. Accused can be defendant, but aggrieved is not restricted to plaintiff. Aggrieved is the term used for anybody who is not satisfied with the order of the court. So it can be the plaintiff, it can be the defendant. That is, in our case, it can be the accused, it can be the complainant or the victim. It is not general. Aggrieved term is generalized, but this person aggrieved over here in our scenario is not generalized. It is subjected to accused person only. Going ahead with the next judgment, that is 1990. Simrika versus Dolly Mukherjee and Chabi Mukherjee and another. The inherent jurisdiction of the High Court. This case judgment is not important. Case name is not important. Okay? The inherent jurisdiction of the High Court cannot be invoked to override bar of review under 362. The court is not empowered to review its own decision under the purported exercise of inherent power. Okay? Please remember Suraj Devi versus Pyare Lal, which says, in the disguise of inherent power, the High Court cannot exercise the power of review. Why is it so? Why is this thing has been stated? In the disguise of inherent power, why can the High Court cannot exercise review power? Do you remember any law? Do you remember anything regarding this thing? रेजिडी काटा कहाँ से आ गया? रेजिडी का नहीं, not रेजिडी काटा. अच्छा, what is the object of inherent power? What is the scope of inherent power? If you remember what is the scope of inherent power, then you will be able to answer this question: why, in the disguise of inherent power, the High Court cannot exercise the review power? Article 151 of CrPC, it is section 151, and section 151 talks about your inherent power regarding civil courts. I am unable to understand you, Anuradha. I am really not able to understand you. तो आप पूरा statement लिखो अच्छे से, frame your answer and give the statement. Yes, everybody, tell me, why is judgment over here stating, in the disguise of inherent power, छुप के हाई कोर्ट इनहेरेंट पावर का सहारा लेके क्यों नहीं पावर ऑफ रिव्यू कर सकता है, एक्सरसाइज क्यों नहीं कर सकता है? बिकॉज ऑफ द सिंपल रीजन ऑफ द स्कोप ऑफ इनहेरेंट jurisdiction. Inherent jurisdiction can be exercised to fulfill the lacunas of law. They cannot be exercised whereby there is an express provision of law. Very good, Mehta. Correct. Whenever there is an express provision of law, inherent power cannot be used to invoke or go against it. That cannot be done. There is section 362 which specifically states bar as to review. Correct. What cannot be done directly cannot be done indirectly. What is that doctrine which Ritik is talking about? What cannot be done directly cannot be done indirectly. What is that doctrine? What is the actual name? The nomenclature of that doctrine. Clear? Please remember, when there is an express, very good. When there is an express provision of law, the High Court cannot say, I'm just using my inherent power and thereby have a right to invoke it. No. You cannot infringe the express provisions of law. Colorable legislation. Very good. Very good. Does anybody remember the most important landmark case regarding doctrine of colorable legislation? Please don't ask me. I don't remember. I'm asking you. Okay. Yes. Anybody remember the most important judgment regarding colorable legislation? This is such a bahana. Consti is yet to begin. ये तो बहाने के लिए, आई वोंट एक्सेप्ट इट. तो फिर मैं इस क्वेश्चन को बाद में लूं. पर आपका ना एग्जाम इस चीज पे बेस्ड नहीं होगा. मैंने ये नहीं पढ़ा तो ये एग्जाम में नहीं आएगा. हर चीज आएगी. Till the time you are searching for it, because I don't remember it. अमृता, मुझे पता नहीं है. I'll accept your answer for now. क्योंकि मुझे बिल्कुल नहीं याद आ रहा है कलरेबल लेजिस्लेशन का. मुझे याद आ रहा है तो फैक्ट याद आ रहा है, हर चीज याद आ रही है. I'm just not able to recollect the actual name for that. So I request everyone कि प्लीज गो अहेड एंड रीड इट कि कलरेबल लेजिस्लेशन का लैंडमार्क जजमेंट कौन सा है. ठीक है, वेरी इंपॉर्टेंट. जब पढ़ाया जाएगा तब पढ़ाई जाएगी. अभी आप उसको देख लेना. नाउ, are we clear with the facts? Over here, we dealt with one single issue, whether second quashing petition is acceptable or not. Yes, it is acceptable under which provision? Under the inherent power. Why? Because there is no such specific law to go ahead and accept the second quashing petition. What is quashing petition? Whereby the accused wants to quash, wants to end, wants to take away, wants to just finish the ongoing criminal proceeding against himself. ठीक है? The quashment petition can only be filed by the accused. The quashment petition is not filed by the complainant. Complainant will never want to go ahead with the quashment. If complainant wants to go ahead with the ending of the procedure, ending with the criminal procedure, then what kind of remedy does the complainant have? May I know? What is the remedy available to the complainant to end the criminal proceeding before him? Not the writ, not the writ. Prohibition nahi. Writ of prohibition nahi. Correct. Withdrawal. Simple, withdrawal. He is the one filing the petition, he will withdraw it. Correct? Very simple, withdrawal. He will simply go ahead with withdrawing it. Clear? But on the other hand, the accused has the power of filing a quashment petition before the court. Now, the second quashment petition or any kind of quashment petition can be accepted or can be filed under invoking the provision of inherent power of the High Court. Quashment petition is filed before the High Court only, not any of the lower court, not anybody, but the High Court under 482 or now the 528 of BNSS. Second petition is acceptable only when. When is second petition acceptable? Yes. What is the one condition which is required to be proved? Very good. Very good. Okay, very good everyone. Change in circumstance. Who will have to prove it? That there was a change in circumstance, or it can be just pleaded by the lawyer. Mehta. फिर से देखो क्या लिखा है. क्वॉशमेंट में अपील. मैं कंप्लेंट से ही कंप्लेनेंट समझ गई थी. फिर से देखो क्या लिखा है. Varuni, I accept what you are stating, but write it properly. The person claiming that relief. Okay, it is not an appeal. And who is the person away? Is it the complainant? No, it is the accused. Correct. Over here, Mehta, please remember, and everybody please remember, it is the accused who need to prove it, not the complainant. Complainant can go ahead with the withdrawal. Fine. And if that new grounds or new change in circumstance has not been proved, and yet the High Court go ahead with the acceptance of that second petition, will that amount to anything, or is it acceptable? Yes. The second petition was accepted by the High Court without looking into the fact whether there is a change in circumstances or not. Is it valid or it is not valid? Good, Ashika. It amounts to review. Under which provision of BNSS there is a bar as to review. Good, everyone. Very good. 403 of VNS is very good. I'll ask the last question. Please listen to me properly and then answer it. The first quashment petition was accepted by the High Court without looking into the fact whether there was a change in circumstance or not. Whether this first petition being accepted by the High Court is valid or invalid. Do you want to repeat? Good. Good, everyone. It is valid because in the first petition of quashment, there is no requirement to look into the fact of change in law or change in circumstance. But what is the requirement in the second one? Very good. Good. And now with this, if I hope NC Ravikumar versus DS something is something which you have understood. You understood the very basic thing. Good. I hope you'll remember the fact that the quashment petition is filed by the accused under invoking 482. The second petition is acceptable if only it is proved there is a change in circumstance. If there is no such proving, if there is no such contention made, even if High Court go ahead, it amounts to review, which is not valid point. Good. With this, I'll end the session for today. You are required to remember one precedent only, that is Suraj Devi. Okay. While you are going ahead with the revision, I'll end the session for today. We'll go ahead with the next class tomorrow at the same time.
Enhance legal skills. Unlock success with RostrumLegal.